So, no, I wouldn't say I have a passion for HR.
Welcome back to Human Resources for the People. It's a human capital revolution. Today we're going to be talking about a court case out of Wisconsin that proves that disparate impact does not necessarily mean illegal discrimination, and that's an important distinction to make. So we go to this case. This is Catherine Erdman versus the city of Madison, Wisconsin, and it was decided this year. It was decided on January 22nd. So Catherine applied to work as a firefighter for the city of Madison, Wisconsin, and she was eliminated in 2014. Some of these cases are quite old because she didn't get the minimum qualifying score in the physical abilities test. So she filed a civil action against the city, saying that this test had a disparate impact on women in violation of Title VII of the Civil Rights Act of 1964. And the district court ultimately held that she failed to prove her claims. For starters, let's discuss what disparate impact is and what it's not. Disparate impact in the context of employment and anti-discrimination law refers to a situation where a particular employment practice or policy, although appearing neutral on its face, disproportionately and negatively affects a specific group of people protected by civil rights laws. Even though there's no explicit intent to discriminate, the impact of the policy ultimately results in a disparate or unequal outcome for certain individuals or certain groups. And you have to typically involve statistical analyses in order to demonstrate adverse impact on a protected group. An example of this might be height or weight requirements. Establishing certain height or weight requirements for a job might disproportionately exclude women or individuals from certain racial or ethnic backgrounds, especially if the requirements are not directly related to the job's essential functions. If these requirements cannot be justified by business necessity, they may be deemed to have a disparate impact. And this is really important because the business necessity in proving relational outcomes from the test to what happens in the workplace actually has, it is very legally important. Physical abilities test represented the physical demands of being a firefighter, and they recognize that picking up and advancing charged fire hoses, forcing entry, performing CPR, lifting and climbing and descending ladders, hearing calls for help, etc., etc. All of these things, the Madison Fire Department found to be essential functions of the job of firefighter, and were recognized as being required for doing the job and recognized as part of the test. And another one is employment testing. If an employer institutes a written test as part of the hiring process for a certain position, if that test disproportionately screens out applicants from a certain racial or ethnic group or gender, it cannot be shown that the test is a valid measure of job performance. It may be considered to have disparate impact. And Catherine Erdman's argument with respect, or her lawyer's argument with respect to this particular one, is that Madison was using their own test. They were using a locally defined test that mirrored something similar to the IAFF test. The International Association of Firefighters has a recommended physical aptitude test that Madison has chosen not to pursue. And the reason Madison chose not to pursue it is really obvious. It would have additional costs, additional overtime, and it would not really serve the goals of the department. However, the IAFF test has less disparate impact than the Madison test overall. It still does have, the IAFF test does have disparate impact in and of itself, but because the test is connected to the needs of becoming a firefighter, it is considered acceptable within the firefighting world. The Madison Fire Department still seemed to be pretty progressive with respect to hiring. They had 404 total applicants, and 4 women passed the Madison test, passed the physical agility test. They hired all 4, and then they hired 13 men. So all 4 of the applicants that did pass were hired. All 4 of the women applicants that passed the test were hired. 14% of the Madison firefighters were women, compared to the 4% national average. So Madison was clearly very sort of ahead of its time with respect to employing women in the fire department. So what do you think about this situation? Should the firefighter test be modified to represent a growing workforce? Let me know in the comments down below. Like, share, and subscribe, and I'll see you on the next video. Bye, guys.